How's it going, everybody? I'm back. I'm making this quick video because I wanted to show you guys what kind of racket they're running over here in the city of Glendale. I believe it's a racket because it's really pretty much the whole state, really, because they all get a cut of the pie here. Um, well, so this is what's going on here. Okay, in the state of California, when you get a traffic citation, and mind you, I know I've probably been over this a couple times, just for those that haven't, and I'm gonna expand on what I've previously talked about. In the state of California, when you get an infraction, what happens is you go to what's called an arraignment, where you plead guilty or not guilty. From there, you go to trial. Okay? You get a separate date, about a month or two after your arraignment. Then you go to trial. At trial, you can call witnesses or subpoena witnesses. You can cross-examine the witnesses. You can go ahead and, file motions. And I mean, really, there's supposed to be a pretrial hearing date, but they're not for infractions, and at least not out here in California. Which is one of the issues I'll be bringing up in Fed court. So, what happens is, once you're done, and let's just say the judge says you're guilty, or commissioner says, she says, or he says you're guilty, and you want to appeal this decision because you don't agree with the judge or commissioner, you can do so by filing an appeal in the appellate division. The problem with that is that here in Glendale, they record the whole thing, and then they turned around and said and sent me a letter saying we have no recording of this matter. And which is kind of funny, really. They're pretty much giving me everything I need. So what happens is the courts call this kind of appeal statement on appeal, because you basically give your statement of what happened from memory, of course, mind you, and the judge or commissioner will give his or her statement as to what happened at the trial. Now, if this is the crazy part, it's all messed up, and this just shows how they need to kind of refresh their memory and recollection, and you know I don't know, but I believe they lie a lot. Okay, let's just get to the point. So what happens is, if the judge says, no, this is not what happened, let's just say you say, well, the judge said the Constitution doesn't apply in the courtroom. He can turn around, and that very same judge you're appealing is going to get a copy of what you said first, before he makes his own statement on appeal. And then he can say, well, that's not true, I never said that. So he can turn around and say, well, this defendant is lying and grossly, misrepresenting the truth. So they can say whatever they want and then turn around and then they file it with the court. Then you go and, I guess, battle it out at the your trial, or the appellate court can look at it and then they make a decision, whatever the case may be. Okay, now, so like I said, in Glendale, what they do is they record it, but they turn around and say, well, we don't have a recording. Okay, and of course, they don't have a stenographic reporter, which is the people you see like on TV. They type away what you say and then type away what the judge says, and then, so they don't have either or. But as you can see on the screen, it says right here, the appellant herein submits this objection to being forced to making a statement on appeal. And I did this because I already had other previous appellate decisions saying that if they don't, that certain things will happen. I said the Los Angeles Superior Court owes Pimentel the duty to have either transcript or an official electronic recording. California Constitution, Article 6, Section 1, the judicial power of this state is vested in the Supreme Court, Courts of Appeal, and Superior Courts, all of which are courts of record. Thus, this court never had jurisdiction. Clearly, Commissioner McTaggart did not know what he was doing. Now, the problem here is going to be for them, because now, I stated in my last video, or one of the other videos, where I called the appellate division and I asked them, what's taking so damn long? It's already going to be 2.5 months, going on 3, for you to say, hey, look, this decision is going to go forward, or you're wrong and it's no good. Give me something. And they said, well, we're waiting for the record from Glendale. I told her, let's just get to the point. They have no record, so if that's what you're waiting for, we're never going to get anywhere. So I'm going to give them a little more time, and then I'm going to file some more stuff with them to make them hurry up and put some fire under their feet. But the crazy part is, that's how they play this game here. So that's why a lot of judges, I believe, and commissioners in California, and I'm pretty sure other states as well, where they don't record like they're supposed to, um, pretty much can say whatever they want, and people think, oh my God, I can't win, and that's why they seem so omnipotent, because it's like they can say whatever they want. Oh my God, be careful, don't talk to them like that. But in reality, they can't talk to you a certain way. They got to be very careful, because they got to seem very, very impartial, and if they don't seem impartial at all, guess what? No good, especially in California, because there's no district attorney present, so they have to seem impartial. Now, I'm gonna prove, and I have the evidence that they weren't. None of them were. So now what's gonna happen? Whoops. Too bad for them. But my point is that that's why they seem like they can do whatever they want, not because they can, but because there's no record to show and expose what they're doing. Which is why I believe they don't let anybody record in courts, because, well, there's many reasons, but one of the main ones I think is because, well, number one, they don't want to get caught lying. Number one, I mean, really. They don't want to get caught telling people they're stupid, like I've heard them in the city of Glendale. I've heard judges call people stupid. Grown men, of course, just humiliating them. I mean, it's stupid. I don't know why they do this, but they do it because, they want to seem like they're untouchable and whatever they say goes, which is the case because there's no proof that they're doing this crap. Okay? Another reason is because, well, just like in my videos, everybody can see my videos and learn from my experience, and I'm talking about what's been going on, because not too many people are recording real cases, at least from what I've seen, and talking about what's been going on in their cases and what traps to look out for, and but imagine if people could record in courtrooms, okay, and everybody shared this information with each other. Now, a lot of people would say, oh, you can't say this because I said this and the judge said, that calls for legal conclusion. Or because the commissioner, well, she told me that I couldn't do that because it violates evidence rule, blah, 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 blah. Or the rules of evidence of whatever. So, now, see what happens is people start becoming informed, well-versed, and rehearsed, and they pose a real threat to the courts because more people will appeal because they'll know that the last person won or didn't win and they have a better idea. That's really what I think is going on here. They want to keep this stuff, and they've been doing it since, what, the 60s, I think. Damn. So, not anymore. This stops here, at least with me. And, of course, another person that I know. So, they're going to have a problem here real quick, because in this case, I actually cross-examined the officer for about almost an hour. So, if they want me to remember what it was that I asked them in about pretty much almost an hour's worth of time, it ain't gonna happen. As a matter of fact, I'm objecting to the whole thing. Now, this was filed, I mean, two and a half months ago. I still have no word from them, and I will soon. I'm gonna make them tell me something. Sooner or later they're gonna have to say something. But so this is a little scam the city of Glendale has going on. So for those of you that are in that city, be very careful. And even in the state, there has to be some kind of record, because it says it right here in the Constitution, California Constitution. So if they're violating the constitutional laws and they're getting federal funding, like for example, well, see, I don't want to get into detail, but I know that, for example, in the city of Glendale, if they're getting federal funding, or if the states even get federal funding for the cities, or the cities are getting federal funding for whatever the case may be, for these official electronic recording devices, and they're being not used the way they're supposed to, well, I mean, let's just say we'll be finding out real quick as soon as I get in there as to what's really supposed to be happening and what's really happening. Because, like I've said before, what the law says and what these public officials are doing are honestly the total opposite, and that's why it seems like they can do whatever they want. And it's not because they can, it's because people don't know how to fight them. I'm not claiming to know it all. Believe me, I'm learning a lot as I go. So but the point is, I'm still moving forward, and it's like I said in my other video, it's been already 3 years for some cases. But the main thing I believe is I'm doing this because I want people to be able to have some kind of record, at least when they go to traffic infractions in the state of California. I want to get that damn thing changed, okay, to where they will have to have it. Right now it's kind of ambiguous, and So they don't have to really do anything, even though the Constitution clearly states that. So that's going to be one of my questions. I'm going to say, hey, I want the federal court or the appellate division to respond to this and give me a damn answer. Am I right or am I wrong? See, once they say whatever they want to say, at least I can say I was right or I was wrong, and then that's it. Okay, and get on with my life, do what I got to do. You know what I mean? But until then, I guess I just got to wait and see what they say. So hopefully you guys enjoyed this video, and just remember that because people say something, it doesn't make it so until you've gone and experienced something. I mean, don't believe people. Just do what you got to do. And if you believe you're fighting for your rights, go ahead and do it, because you know what? It's your rights that are being violated and nobody else's. Which is why I've been laughed at. I've been called names. And you know, and believe me, I see a lot of fear in these comments that I have on my website here on YouTube. And they should be very scared, really, because where I'm going, I can tell you right now, I can guarantee nobody's been here before, as far as these questions, and that's only because I've been doing a lot of studying and seeing what questions have been asked, and that's how you learn. Oh, can't ask that question because somebody already asked it and they were wrong because the appellate division or Supreme Court or, you know, Fed court said this. If this would have been asked, it would have been different. So that's how you learn, and so I know what not to ask, what to ask, and how to be careful and word it. So you know, I hope you guys enjoyed this video, and I don't know, I guess that pretty much covers it all. Yeah, pretty much about covers it all. So I guess my next video will be of what I'll be filing in Fed court, or what if I've already filed it, you know, whatever the case may be. But I gotta work on it. I sound tired because I haven't slept since yesterday morning. It's already 9:03 a.m. here in California, so I've been up all night, 24/7, and this is what I do. This is what I love. I love proving to these public officials that they're not gonna screw me over and get away with it. As a matter of fact, this is just beginning. I just can't wait to see them in federal court as defendants. Are they judges? No, no, that's not a judge anymore. That's defendant McTaggart, or defendant Green, whatever her name was. So hopefully you guys enjoy this, and believe me, I already know I'm going to expose more stuff later on down the road, and this is only going to get bigger, and it's only going to cost me $300 from what I understand. So when Commissioner McTaggart told me if I wanted to pay those, like, what was it, $1,500, I laughed and I said, Your Honor, come on, you know where we're going to go with this. You know, it's kind of crazy. It's to the point where the fees are so high, and I was looking at DNA fee and traffic accident fees and all these weird fees and court costs that they attach to something that it doesn't even apply really, but they, you know, I don't know how they get away with it, but they do. I haven't looked into that yet, but my point is, it's actually cheaper to sue the city and state, and in a lot of cases people have the proof, they just don't know they have it. And so when it gets to the point where it's cheaper to sue the state, what the hell what do they think these, well, I mean, it's crazy. What do they think we're gonna do? Oh, here's your $2,000 because I didn't put on my left blinker when I should have, and nobody was around but me and the CHP, or me and the peace officer. I mean, they're crazy. It's like, man, you better tell your wife to not be mad and to forgive you, because she's gonna be joining your ass in federal court. So, you know, but you know, people will learn from their mistakes, and these officers will learn. I told them. So hopefully you guys enjoy yourselves, and this is me signing off because I'm ranting and raving now.